We are trying because we have to manage certain matters that.
Most grateful.
Grateful.
Most grateful.
Milord, I want to just clarify. I have given the IA numbers that has to be withdrawn. All the petitioners have withdrawn the case.
So all the petition means then your SLP. has to
SLP
be
is withdrawn. Deeply
Okay,
obliged.
thank you.
Deeply obliged, Your Lordship.
So hope now this order is the final order.
Yes, Your Lord.
All right, done.
I'm really grateful, Your Lordship.
Thank you.
But in item 1, my lord, I have done 3 things. I have filed, my lord, an affidavit in reply and 2 status reports, one for CBI, another for ED. And as per, my lord, my reply, the approximate siphoning of the funds we are looking at right now is about 40,000 crores. And the investigation is ongoing. This is, of course, my lord, bank's public money.
40,000 crore. But
40,
the point
40.
is, there are 2-3 disturbing things. One is that, are you presenting CBI also?
Yes, yes, my lord, CBI, ED both.
They have
Now
filed,
CBI says that on the basis of the complaint received from one bank, FIR is registered, matter is being investigated. Meanwhile, from other financial institutions also, complaints have been received. Now they say we want to register separate FIR.
We do. No, my lord, what we have done is I have taken specific instructions on that. The first FIR came from the State Bank of India. Thereafter, my lord, other banks also intimated us about their, my lord, alleged siphoning, etc. That is also now included, and it's a part of, my lord, the investigation. Because we cannot have separate FIR.
These complaints, are these not, these not amount to constituting a separate independent offence? Nature of the offence may be same.
Yes, my lord.
Nature of the offence may be same, but in terms
The
of
transaction as, my lord, used
the
in the judgment.
complainant is different, the time of transaction might be different, the manner of transaction also might be different. Ultimately, so therefore that will constitute an independent offence. Why are they not registering those?
Lord, that can be done. We will examine. Possibly, my lord, there was a consortium lending. If that is so, then perhaps, my lord,
If it is a case of consortium and the lead bank has made a complaint, understandable. That will, provided that the lead bank says it is for and on behalf of all the banks.
No, my lord, the lead bank says only for it.
Ah.
That's correct. No, we will examine that, and we are not averse to registering separate offences if these are separate severable transactions. There is no difficulty.
actually, my lord, in this case, this FIR has been registered in 2025. The Bank of Baroda's audit report came in 2020, in which they had detailed the manner in which the funds have been siphoned out, etc. So the bank unfortunately did not, for 5 years, did not lodge this complaint with the CBI. Only in 2025, they seem to have lodged that
That's
complaint. And till today, my lord, only after your lordship issued notice, they have effected the first arrest in the matter day before yesterday. Till today, my lord, in a bank fraud of this kind, this is the largest corporate fraud in this
So,
country.
now that it has been brought to our notice,
Yes,
and we will continue to monitor it,
yes,
and we will ask them to file status report.
yes. That's what we
That
want.
will,
That's
that will
what-
have to be done.
That's what we want.
My lord, may I make a submission? My lord, I appear for R5. There are, my lord, 5 FIRs by CBI representing, my lord, a large number of banks. There are 3 ED, my lord, ECIRs based on that. There is 12,000 crores worth of attachments, my lord. There are, my lord, more than 100 summons issued to various people, my lord. They are cooperating. It's not nobody is running away, etc. So, my lord, whether we have an SIT or whether they are going on, in the affidavit filed by ED, they have set out, my lord, all this what I am saying, that this is what they are doing. And they say that, my lord, they are doing it with great speed, my lord, etc., etc. That's for them. Now, as far as, my lord, I am concerned, I had a proposal to make. I am not, my lord, averse to an SIT or whatever, my lord, I am not opposing. I have a proposal, my lord, in the sense, my lord, since the government is here, it's a matter, my lord, of money. They say it is siphoning, I say it's not siphoning. But whatever it is, there could be business losses, etc., etc. I have not run away, I am very much here. My lord, if through the good offices of the court and the government, if they can form a committee, my lord, of finance people like SBI, RBI, etc. And my lord, let's have a look at it as to what is the amount due. And if this gentleman or his companies can pay in some staggered form, it can be, my lord, that is one way to look at it rather than going only for prosecutions. That's, my lord, my instructions, and I'm stating so on instructions.
My lord, I have something to say on
In
that.
fact, my lord,
Only
they
a
have
minute,
taken
only a
Check
minute.
to my lord, the Chief Justice, my lord, taking a call
the
on
loan.
the
My
government.
lord, only a minute, my lord. We, the banks, my lord, conducted a forensic audit by an outside forensic auditor, my lord. And the forensic auditor has said that there is siphoning and other things, my lord. My lord, we may perhaps not be able to, my lord, compound these offences, my lord, even if there is a readiness to pay.
That is what,
Mr. Solicitor, in spite of what you are submitting, see paragraph 27 of the CBI report. You are dwelling on 17 capital A again. If the forensic auditor says that there was a breach not of loan terms but of collusion, then what is the question of stopping the registration of RCs in view of taking sanction? These are
that-
Well, I
clear
just point-
operations. Please
that is-
examine.
that
I will answer my lord's question. I have put it to the government, my lord, to the CBI.
23 may
that was in fact my next.
Yes, yes, your lordship's question is very pertinent. My lord, the public officials are also under the investigation. They are also under investigation. Number two, the respondent number 5 and his possibly respondent number 5, the individual, filed suits in Bombay High Court, and there is, my lord, an injunction granted not to act upon the forensic audit report, my lord, on the ground that the person who signed the forensic audit report is not a member of the Institute of Chartered Accountants. I am not going into it. Banks have filed an appeal. Appeal is heard and the judgment is reserved. My lord, I appeared for the bank as well. My
I
lord,
appeared on, that's a completely different issue.
different thing, my lord.
We are
But-
entitled to say a report is good or
No,
bad.
no,
That's a
I'm not on the merits.
That matter has been argued, so we'll wait for the.
Yes.
different- Judgment will come soon in a week or 10
Even an
days.
injunction has to be subject to 41 of the Specific Relief Act. You can't get an injunction on
Lord,
registration of an
injunction
FIR.
perhaps may not apply even
Absolutely
to
not.
an independent
But we are not
investigation.
arguing that case here, my lord. Question is, there is a report which, my lord, declares me as a fraud. Report is issued by a person who is incompetent to do so. So I am questioning that, that's
Mr.
all.
Rodriguez, there are two things.
Yes,
If there is an intention to
Yes.
siphon the public funds
yes,
from X to Y, Y to Z,
yes,
from the very beginning, and if that has actually happened, then probably the solicitor is right in
Yes.
saying that this kind of offense can't be merely because you are willing to pay.
agreed,
you
my lord,
pay,
agreed.
That
agreed.
may not amount to condoning.
Absolutely right. But, my lord, it is my case. There was never an intention. We have done business, my lord, for
That is
40
the-
years.
That is what precisely
Yeah,
has to be seen on the basis of the investigation.
no problem.
Now,
Investigation,
investigation, as my brother has pointed out,
No problem.
we will not allow this kind of impediment that 17A sanction, this and that. If the bank officers or some officers
They are
found
also
to be-
under investigation, I am instructed.
If they are not involved, it's fine. But if they are involved, then they must
If
also
they are
face
in
the brunt.
collusion or in any way accomplice, then they are also under the investigation.
That's okay.
I am
But I am
authorized-
not opposing, I am not opposing anything. I have come, my lord, with a proactive stance. I have cooperated. I will cooperate. Whatever else your lordship will direct, we have.
What you are suggesting, Mr. Roki,
Well-
that can be, that can only be probably from your side, it
Yes.
can come. Provided that after thorough investigation, someone says that it was a case where the default took place for the reasons beyond your control.
That's right.
Out of the
No
alleged
problem.
It was not misappropriation, misapplication or
Application.
something. But
That's right.
it's a deliberate siphoning
But
of.
it can
It's a
happen.
criminal offense.
It can happen, my lord. People do go bankrupt.
even
It's
if
not
we
that every man, my lord, has taken money and run away.
Milord, I just want to
Even-
complete your-
even
because
if we
I-
ignore
if your
the-
lordships will just permit.
the audit report of the bank, the ED in their counter affidavit is saying that they have found evidence of forged bank guarantees being given by them. They have
Then itself is a
It's a
independent
criminal
offense.
offense. Therefore, I said it may not be possible to
forged bank
compound that
guarantees,
offense for merely
siphoning
because
out
somebody.
to all these tax havens. At least 26,000 crores has been siphoned out to these tax havens like Mauritius, etc. Not a single penny has been cuffed up. They have declared bankruptcy in all their companies. 1,78,000 crores of outstanding dues in these companies. 1,78,000. The only amount recovered in bankruptcy proceedings is 15,000 out of 1,78,000. Most of the
huge
money
amount.
has been siphoned out. That gentleman, my lord, who owns all these companies, he has not been arrested till date. Till date, my lord, the main person, the kingpin of this whole scam has not been arrested. Only they arrested one officer of this company 2 days ago, day before yesterday, only because of this matter coming up.
No, not because of that.
We will not comment, Mr. Solicitor, but then it's a very serious.
Lord, we are before your lordships and we will have to ensure that your lordships conscience is satisfied that the investigation is impartial and going in the right direction.
Today we are not passing any harsh order because someone may not take it that our order has caused prejudice. But we expect that your agencies must act fairly, independently, and very swiftly. We would like to have status report every month. In 4 weeks, they must submit the report, and let us see how you take the investigation to what logical conclusion.
Please,
If so much, such a huge amount has been siphoned.
it is.
Then we are.
Lord, this is not correct. This is absolutely not correct. Just banding figures like this.
No, just 2 points.
It's absolutely
I
incorrect.
just want to clear the impression.
One you are presenting.
I'm appearing for respondent number 4, which is the group of companies.
The companies.
So here, Manoj, I might just mention that the service, because the impression carried, I think last time when your lordship passed the order, was that service was effected and we were not appearing. In fact, we have received the papers only after the 31st of January, because I don't know which address they went to etc.
Anyway.
But anyway, now we are on record. We've placed our thing. We'll take some time to put in our response.
That's it.
etc.
Okay.
I'd be grateful for that. The second point which I want to mention, because a large number of figures have been bandied about, that in the last 5 years, 2 of the companies, Reliance Infrastructure and Reliance Power, have paid back a total of 20,000 crores of rupees. 20,000 crores of rupees. Now, this is a very, very
But
important
the
element.
amount is 1,78,000.
Lord, this-
What I'm trying to get,
This
what
is not
that
correct.
people see, Manoj, that
Yeah,
those
this is
figures
not
are being
correct.
bandied. What we are trying
Absolutely
to
banned.
project over here is that when a party has repaid 20,000, and these 2 companies are now virtually debt free. I mean, there will be obviously some requirement for working capital,
Thousands of
etc.
shareholders.
But it's over, Manoj, something like 50 lakh shareholders, small investors are there as far as these 2 companies are concerned on the aggregate. So this is, my lords, obviously a group which repays the amount. Now we will, there, as your lordships may have seen from we don't have the advantage of the report, but we do have the Enforcement Directorate affidavit which has been
Yes,
filed.
we have.
Where there's a series, the affidavit says that there's a series of steps and measures which have been taken in the last 6 months. So there's a relentless, my lords, effort. We are trying to ensure that the payments are made, and there is no question, my lords, as far as this suggestion of siphoning, etc.
Just one company.
Anyway,
Not
we
only
will-
one
we will
aspect.
bring- And therefore, my lords, I think the suggestion which was made by Mr. Roti is a valuable one. Most of you see the Enforcement Directorate affidavit also. That's all that we have. They have talked about public funds, etc., being siphoned away or being removed. Now, that doesn't seem to be the correct impression, which the Enforcement Directorate, but they're entitled to their view. So therefore, if there is some solution which can be found to bring this out, at least it reduces the issue, because that's the primary
There are
purpose.
two,
Now let us see that. How
let me respond, my lord, on 2 aspects, my lord. Number 1, Lord, in the forensic audit report, Lord, it has come out that in some cases, the money is taken as a loan from one bank to repay the another bank. That may be, my lord, I'll have to check up, my lord. That may be the way in which, my lord, this is repaid. Second, Lord, this suggestion placed before your lordships may not be utilized in other forums that now Supreme Court is considering constituting a committee which will go into what is payable and how to pay it.
No,
Because there are suits and petitions pending.
Mr. Solicitor, we are not constituting any committee today.
Yes, my lord, right.
We are still expecting and we are hopeful that CBI and ED will do their job. They know how to do it. We are expecting them to perform it. If at all we find that yes, there is some kind of delay on their part, or if they are evading anything, then we might require to.
No, certainly, we are before your lordships, my lord, and
Lordship may see that, and then take a call. We have no difficulty. We are not.
Just 2 companies of theirs have outstanding. Reliance Communication Infra had 47,000 crores of outstanding dues. In bankruptcy, it was sold off for 455 crores, 1% of the total outstanding amount, and sold off to whom? To the brother's company. And the other one, my lord, Reliance Communication had 47,000 crores of outstanding dues. Just two companies have 95,000 crores of outstanding.
Lord, resolution
Both
is
of them have been
pending.
Sold off.
It's a public process. It's a public process. It's not that I am buying or brother is buying. Anybody can come forward and buy or not buy.
It's not
The
buying
res-
also, it's a
IBC
resolution plan being.
Unfortunately, IBC platform is nowadays is being misused like anything.
That's,
You get the company, all the assets undervalued, then you indulge in a kind of an auction, which is also a completely a pre-planned,
Lord,
game.
these kind
Lord,
of,
only one thing.
Somebody from the family or close friends or someone comes and buy it.
Lord,
If the brother has done it, the value assessed is something different.
I don't know about, Lord, I'm not aware.
Apropos what has fallen from my lord the Chief Justice, the government of India is also seriously considering this issue, my lord, in IBC. And I cannot, my lord, say much. I'm a part of the discussion, but it is under a very serious consideration.
Because every day the matters are coming, and this is one of the issues that every day we are facing it.
My lord, the haircut is phenomenal, sir.
And the bankruptcy is declared by the very company which is facing bankruptcy. They asked one of the
Voluntary
sister companies.
declaration, then your own people evaluate you, that evaluation is not even 1%, 10% of the actual market value, and then eventually you find out this, unfortunately, this resolution professional or whatever designation is given, every day I keep on observing, their conduct is also not above board. So let us see that after 4 weeks,
You
that
don't
how
even
it
see that.
come out.
No difference.
Please, sir.
Mr. Bhushan, all these facts are there on record now.
Everything is on record. Everything is on record.
Lord,
This
we will
Lord-
also respond, my Lord, to these figures. They are not correct. We will respond.
Say in reference to the order dated. Twenty-third January 2026. Arrest number 4 and 5 have entered appearance. Their learned senior counsel seek and are granted 4 weeks time to file the counter affidavits. And say, Mr. Solicitor of India, Mr. Tushar Mehta and Solicitor of India, you are representing both ED and CBI.
Both, yes.
Representing the Enforcement Directorate and Central Bureau of Investigation state that the like this, the Enforcement Directorate and CBI have also entered appearance to learn sources of India. The Enforcement Director has also filed an affidavit. In sum and substance suggesting that the investigations for the purpose of detecting the offences under PMLA as well as into the affairs of the group companies are going on. It is pointed out that ECIR stroke STF stroke 17 stroke 2025 has been registered in relation to the Reliance Commercial Finance Limited and Reliance Home Finance Limited. The investments made by Yes Bank between 2017 to 2019 in non-convertible debentures and commercial papers of both RCFL and RHFL are being examined. According to ED, it has been found that RHFL borrowed public funds from 33 banks, stroke financial institutions, and committed a default of rupees 7,523.46 crores. It is further claimed that 33 lenders have been able to recover only rupees 2,1106.28 crores, with a net default of 5,407.33 18 crores, which constitutes the proceeds of crime. As regard to the default committed by RCFL, it is pointed out that 21 banks stroke financial institutions have been defrauded to the tune of 6,280.57 crores, as out of 8,226.05 crores, only a sum of which 1,945.448 crores has been paid. Another ECIR stroke STF stroke 26 stroke 25 has been registered in relation to Reliance Communication Limited. Inter pointing out that the total outstanding amount is 40,185.55 crores, which constitutes the proceeds of crime. It seems that one ex-director of the company has been arrested recently and is in custody till 7th February 2026. Next paragraph. The third ECIR stroke STF stroke 14 stroke 25 2025 pertains to Reliance Power Limited. It details of the factual details of the RPO WER entering into a power project agreement wherein forced bank guarantees are alleged to have been submitted. Defects. Were submitted. The total loss said to have been cost to the public money is 105.98 crores. The individuals who have been associated with the aforesaid company have been arrested. That's paragraph. The Enforcement Directorate has further explained that it has searched 46 premises, issued 13 POs, and has attached 204 properties valuing 12,012.45 crores. Main paragraph. That's right. Having gone through the counter affidavit of the Enforcement Directorate, it appears to us that the aforesaid agency is expected to the aforesaid agency must look into every possible financial transaction suspected to be which might have led to the siphoning of the funds, and determine the estimated value of the proceeds of crime. In this regard, the Enforcement Directorate is well advised to constitute a special investigation team of its comprising its senior officers and take all lawful measures to take the ongoing investigation to a logical conclusion. It may not be appropriate for us to express any opinion at this stage, except to observe that there has been an unexplained delay. There has been an unexplained delay on the part of the investigating, on the part of the ED.
For both.
ऐसे तो यहाँ तो दोनों का इकट्ठा लिख दो यहाँ पर That's ऐसे तो भी. Similarly, a report in sealed cover has been filed by CBI in bracket risk number 3, which has been opened and used. It seems that a formal FIR was registered on the basis of a complaint received from State Bank of India. According to CBI, the complaints received from other banks stroke financial institutions are also being investigated by enlarging the scope of the said FIR. Such a reports adopted by CBI, apparently, it does not seem to be in conformity with the procedural law, as is complaint, even if it pertains to defalcating of public funds, is based upon its own unique set of facts and therefore would constitute an independent offense.
Also touch upon 17A. Also touch.
Furthermore, it is imperative from the CBI to investigate the conduct of the bank authorities as to whether the financial assistance was released from collusion and connivance with the management of the companies in default. In this vein, the reference by CBI to Section 17A of the PC Act is totally misconceived. We direct that regardless of any such provision, the CBI must look into the nexus, stroke collusion, stroke connivance, stroke conspiracy, if any. For that purpose, all lawful measures to taking the investigation to its logical conclusion be adopted. Next paragraph. We may hasten to add that both agencies, namely ED and CBI, have already taken their own time in swinging into action, and any further delay will not bring, and the further delay it will be in a positive way. And we therefore expect that both agencies will act promptly, independently, fairly, and in a dispassionate manner. Aaj Bangla. that status reports by both the agencies be filed within 4 weeks, post the matter for further consideration on so and so date.
Only
One last thing.
One small request, only.
Since
Mr.
your
Kush-
lordship is now monitoring this matter, there is now serious apprehension that the owner of all these companies, my lord, the person who owned these companies, he may flee the country. Now, they have not arrested him. They have
Why
not
should he
even
make
issued
that
a
statement?
lookout circular.
I am in India, I am
They
before the
have
court,
not even
I am not
issued a
running
lookout
away, I
circular.
am not going anywhere.
Which will prevent him from fleeing the country. So many people, my lord, with tens of thousands of crores outstanding have fled the country.
There is an
At
LOC
least- at
against
least
him, my lord.
There are several LOCs. I have not gone. I have not attempted to go. I am, my lord, working in my office in these companies even today.
That I think that having been issued, they can't now.
And I am not going, my lord. There is no question.
Lookout order.
Lookout
should issue a
circulars are
lookout
issued.
circular.
There are several of them, not one.
They can't allow him to flee the country. At
Arre
least a
bhai.
lookout circular, even if they are.
Why is
not-
my friend making this statement, my lord? Is there any material to say that I have fled the country or have fled the country?
You have.
We have repaid 20,000 crores in the last 3 years. If I had to go, I would have fled earlier. Not now.
a per-
Why do you make these kind of statements?
Now because
Just because of the press?
Because the court is monitoring the matter now. That's why I'm saying.
So where is the?
That's why.
Show me one stretch, one shred of evidence to suggest, my lord, that this man is running away.
Solicitor General, you, whatever necessary steps are required, because we do not want anything to happen which may frustrate the ongoing investigation.
I understand.
You
but
must
A
take-
line from your lordship, my lord, would really.
We must take whatever preventive or other measures are required to be taken. We do not want that investigations are hampered at any cost.
My lord, statement, I will not leave the country without the leave of the court. What more is required?
Lord,
Just to make, my lord, allegations against us?
My lord, only a minute, only a minute. My lord,
At this
my lord, there is something I want to say at this stage.
stage, Mr. Prashant Bhushan, learned counsel for the petition.
R5, my lord.
My lord, before your lordship dictates, my lord, one thing.
Huh.
My lord, I respect Mr. Rodgi's statement, but in past, my lord, he has also burnt his fingers. He made a similar statement in favor of one of the clients, my lord, before Delhi High Court, and the person did flee. I'm not saying, my lord, about this person.
But he came back and he paid 5,000 crores to this government.
That-
Let's be
But
very
after
clear.
5, 6
Once
years, but
he-
sometimes,
once
my
he-
lord, statement becomes, my lord, embarrassing for the
Once
counsel.
he is out of the country, what good is a statement? Once he leaves
My
the
lord, then
country,
there is no reason to trust anybody. Then there should be no revised statement should be recorded about anything.
in a
What
matter
is this
of
kind of argument?
time.
What we will
My
say
lord,
at
one
this-
will flee
at
after
this
the
stage-
statement for if
At
100
this stage,
people.
Mr. Prashant Bhushan, learned counsel for the petitioner, states that,
Very, very unfair.
that
Make these allegations.
owing to the alleged, owing to the amount of alleged fraud involved and the action now and the matter having, being investigated under the supervision of this court, comma, there is every likelihood of the principal accused fleeing from country. On this, Mr. Mukul Rothgil and senior counsel representing respondent number 5
Yes, ma'am.
states that that his client will not leave the country without prior permission of
Of this court.
without prior permission of this court. Full stop. Mr. Solicitor General of India, and assures that all remedial actions,
Preventive actions.
preventive
Preventive.
and remedial actions will be taken to ensure that no impediment is caused in the ongoing investigation.
Yes, certainly.
That's fine.
Because the
I'm
other,
grateful, my lord.
because we haven't had the advantage, of course, of these sealed envelopes. We really don't know
They
what
are
is in it.
pending
We
investigation.
know this we know this a bit about the affidavit which the Enforcement Directorate has filed. So, Manoj, your lordship may give us 3 weeks because at this stage,
4 weeks we are done
yes, for a counter affidavit.
for counting.
Yes. Please do that because this is on denials. We are denying these allegations fully, Manoj, because otherwise the court ultimately is
We
going
are
to
not
take
taking-
appellate remedy.
That's why we are very careful in
Yes, your
using the
lordship.
word.
We have seen them.
And
That-
we are also granting you time. 4 weeks.
Absolutely.
I'm grateful, my lord.
Would like to.
Lord, kindly come to page number 63, my lord. Lord, 2 years after construction of the overhead tank, kindly come to page 63, my lord.
Commercial loans also there with the bank. And I have paid everything. I have got no due certificate.
63, my lord. Lord, we had constructed a overhead tank, my lord, for the purpose of this Ilayangudi village. And my lord, we are
The water tank.
a water tank. And my lord, a small panchayat office is there. My lord, on a land, my lord, disused land, my lord, which was originally, my lord, a village pond and later classified as, my lord, a disused land. My lord, in fact, we have an hydrological report also saying this construction will not anyway affect in other part of the land, my lord, which is retained still as a pond. My lord, the High Court, my lord, directs us, my lord, to remove, calling it as an encroachment. My lord. And thousands of, my lord, yes, my lord.
And water, public use.
And 3,000 direct beneficiaries of this water. My lord, fresh matter, my lord, coming for,
Issue.
delay also is there.
Delay condone, issue notice returnable on so and so date. Meanwhile, operation of the interim judgment of the High Court shall remain still.
Lord, R1 is the writ petitioner, others and all were respondents, my lord, along with the former councillors and all.
So notice returnable on so and so date. जो है, delay भी इनको सुनकर के कर दे तो ज्यादा delay. Review is 107 days.
ज्यादा नहीं है इसके बाद.
And bill 380. So 900. Returnable on so and so date.
Stay, my lord.
Number one being the contesting respondent, comma, the service on pro forma respondents is dispensed with. Respondent number one may be served through dusty notice also. Meanwhile, operation of the interim judgment and order of the High Court shall remain stay. Consequently, the water tank, there shall be no demolition of the Panchayat Bhavan or the water tank.
Grateful to you, lord.
Okay, please, your lordship. This is another interesting kind of bank fraud. It's, every day, my lord, they come out with
Serious objection for saying this one.
unique ways.
Absolutely.
हुआ था, दो questions.
Your lordship should see how a genuine transaction is put into so much of court pressure. We should give us 2 minutes, my lord.
I appear for.
Genuine commercial bank transaction put into so much of pressure and anguish, my lord. Please see the number. We have recovered 116% of the loan amount. And now he wants an inquiry. Absolutely a roving inquiry without any basis. Please see the numbers.
They are so worried that they don't.
No way.
So this kind of slings in the dark. What the High Court says.
Bhushan, you have also
Highly
to understand that this is a commercial transaction where the ledger value has already been
Recovered
assigned
and more.
to the auction. Then
No, my lord, ledger value has not been recovered.
that's
In
the
fact,
finding, sir.
no, the company itself says that they have made a profit of so and so because
Oh,
of this one-time settlement. If your lordship now turns to page,
Kindly turn to page 30 of the.
actually, my
High
lord,
Court.
at page,
Page 30.
we have analyzed at page 189, what was due and what has been recovered. By the, if your lo-
Come to page 9, 7.2. It
Yes,
is
7.2.
116% of the ledger.
Please,
value.
I've got the calculations. Lordship may see the
that is,
calculations.
not- that,
This is not trouble.
that is only the principal amount, not with interest. What was due with interest is, my lord, given at page 189. Otherwise, there would be no need for a one-time settlement. The only reason why they entered into a one-time settlement was because they said, and the bank said that, look, now the property has been devalued from 2,600 crores to 970 crores. Something very astounding. In 2021, my lord, this hotel was valued by the same valuer for the bank at 2,600 crores. 3 years later, in 2024, the same valuer values this same hotel at 970 crores, 1/3 of what he valued 3 years ago.
What was the mode of auctioning?
Mode of, no auction. What they said was,
Two options,
it's a settlement. What they said was, we will enter into a one-time settlement, and the one-time settlement.
Concept law, comparable, that was wrong. If you have a hotel use, the value is lesser than a commercial use, that's why it was done. And after I had paid everything and obtained a no use, this petition is
my
filed.
lord,
How much was the total loan
yes,
liability?
my lords may see, my lord, the court has gone into, lordship may see the sheet of paper,
I'll
only one
just
sheet,
show-
my lord, which we have given to your lordship.
If your
And see the second sheet. Only two sheets were,
Tell us, how much was the,
my lords may see the numbers. Yes, your lordship may see the numbers. Loan sanctioned is
Loan with
242.61 crores.
240?
I have given the sheet, my lord. I have given a sheet of paper with these numbers. Yeah,
Very
please.
much.
Yeah, please.
that was the original
Yes,
loan.
one minute, please, Mr. My lord, loan sanctioned is 242.61 crores. Ledger balance at the time of OTS is 226.54 crores. Total amounts recovered is 414.6 crores. Profit of 172.
No,
It-
Mr. Venkataman, this 242 crore was given in which year?
I'll give the year in a minute. I'll give it in a year in a minute.
March
2015.
20.
2015.
15.
Yes.
Now, out of this principal amount of 242,
They have paid so far, 400, including all the settlement, 414.63, line 3.
that 414 is paid only in OTS.
No. If your lordship sees the second line, 242 came down to 226 at the time of OTS because interest, always bank takes interest first. So once OTS has been compounded, the total amount recovered by the bank is 414.61 crores. And my lord, the date of declaration of the NPA is 31/12/2020. Bank sanctioned a one-time settlement of 265 crores.
No. This 414 crore is paid when?
No, my lord, since inception, my final payment was made in 20.
Actually, my lord, at a glance, your lordship can see.
What is amount in 2023?
In the COVID period, the hotel was empty, we were declared in NPA.
NPA?
The hotel is empty, it can't pay anything. That's across the
For
country.
3 years.
When they created a default, we challenged it. He said, we are not a default, when the hotel is not establishment. can't-
No, Mr. Rothgi, if the account is declared NPA
Yeah.
and the assets of the borrower are valuing more than what the total due amount, in that case, normally, what these bank people do, they always go for auction. They don't allow a poor resident.
No, we exercised option twice.
100 square yard house, they will throw him out, will put him in auction because
We went for auction twice and it failed. We have exercised that option. It's not that bank has not done it and it failed.
We questioned it. In COVID, the hotel was empty. He was suffering a loss of 100 crores. Lord.
किसी गरीब आदमी को इसको ना।
And my lord, please see
Prior to COVID,
on the valuation.
1 minute.
prior to COVID, we were fine.
there.
COVID, Lord, created a problem for all kinds of, Lord, luxury establishments like hotels. We were questioning, Lord, our NPA. Finally, Lord, this was the figure which was being.
No, but this unfortunately settlement is in 2025.
Now, yes.
2024.
So before, in 2025, on 24th January 2025,
Yes.
before that, when did you put the hotel for auction?
Yes, for 2 days. We have done it twice and it failed. We'll give the dates. Twice we have done the auction, we'll give the date. Asset reconstruction auction will not took place in 2 dates. Lord,
2023.
P6 and P5, my lord. P5 and P6. One is, my lord, dated
कहाँ है प्रिंट?
It happened in 2020. 2023. Yes, yes.
Office bench के लिए है बीच में That was not there.
5/9/2023 and my lord, 29/11/2020.
No, 5/9/2023, what was the highest bid?
No bid was received in both.
After, then, in 5/1993, first of all, please show us the records of the auction. Please produce the record of the auction.
We'll do that. Will you not kindly
After
tell?
1993, 2023, then you are entering into an OTS on 24th January 2025.
Yes.
Even a layman in Delhi can take notice of this fact that what is the value of a five-star hotel in Delhi?
Just
Lord,
see.
There was a moratorium stay for
Just see-
3 years
just see
because of COVID.
Page
So, my lord,
So that 3 years is
High
over.
Court, because of a High Court order.
If your lordship
That
just
3
sees.
years is over when in 2023 you try to auction it. That
Yes.
means that 3-year moratorium period was over.
Yes, yes.
Now from 23 to 25, when anybody on the earth can take judicial notice of this fact that the value of real estate properties are rising, and you have a 5 or 7-star hotel here, you enter into an OTS. Before that, you don't make any attempt to auction it.
But we have done it. My lord, with great, there are 2 facts have not, my lord, the High Court has recorded 2 facts. My lord,
Now,
2,
please produce the records of the auction. We would like to see it.
Yes.
Your Lordship, just 1 second.
In fact, my lord, if your lordship turns to page 252, just turn to page 252.
my lord, nobody
is-
can then come, enter into a
just
commercial understanding of an
page
OTS.
252.
When, my lord, in IBC process, 90%, this is a case of a recovery of 116%. Your lordship is now, my lord, to say that this should be,
As a matter of principle, in the commercial wisdom of the banks or the financial institutions, we will not interfere. There is no question of it. But when we are talking of your commercial wisdom,
yes,
we also know it very well that you are not a private entity.
no doubt,
The funds which you have are the public funds.
no doubt, my lord.
These are this money belong to the people of this country.
Yes.
Therefore, your commercial wisdom is for the purpose of giving undue benefit to a person, or it is to protect the public interest.
Which is not
That
their
part will
case.
have to be
With
investigated.
greatest respect, my lord, today, the case of the petitioner is a roving inquiry. He doesn't make out any case.
We are not concerned about the petition.
Yes, answerable to the court.
We will go to the extent that the petitioner has been planted by some rival. Somebody who wanted to buy the hotel couldn't buy. Let us take it like that, worst part. But now that a fact has been brought to the notice of the court,
Yes.
we should satisfy our conscience that the things have taken place in a transparent
Yes.
and fair manner.
Lord, which is what the court has said.
If your
We'll take the
lordship
findings of the court, my lord, but finding after finding.
just sees one page.
Hotel was not, my lord, having any default prior to COVID. It suffered a default. The government of India, my lord, also issued circulars in regard to this period of default. If I have come out of it, they did try to sell. After that, I am back on my feet and I have paid. Is it a case?
Mr. Rotigi, we have no difficulty. Every day, day in, day out, in matters before us,
Yeah.
the plea taken by these very banks is, we will not enter into any OTS because the value mortgage by them is much more than my loan amount. Therefore, why should I go into OTS? This is the consistent stand they take before us, that we are not going to accept any OTS because we have an asset, we will auction it and we will recover entire amount.
But, my lord, is it appropriate that a man who suffers, my lord, great losses during COVID, not a single room in the hotel, my lord, was functional?
No, we are talking of, had the settlement been in 2020,
Yeah.
things would have been different. The settlement is taking place in 2025. This OTS is in 2025,
Yeah.
when the entire, hospitality sector, the hotel, they are flourishing.
Yeah.
They have wonderful business, each one of them making money. A five-star hotel in Delhi has its own value. People know it very well. Who is going in the street, who is going to believe it, that this hotel has a value of 300, 400 crores? When the value might be 4,000, 5,000 crores?
It's not.
They do- well, 4 valuation reports are
The debt
on.
was only 200.
Four.
The debt was 200,
Fine.
250. It is settled at 400.
Why
Therefore,
settlement?
two things, let them produce. First, produce your ledger books that if going by the rate of interest and all, as per the original loan agreement, what was the total amount as on 24th January 2025.
We shall, my lord, this, a special committee comprising of a retired judge and 4 other bank has come, but this OTS was decided ultimately not by the bank alone. It had 5 people in the committee headed by a retired judge, which decided what should be the OTS amount.
Then immediately produce this report. We would like to see the report of that learned retired judge also.
No,
Please
it's
produce that report.
I just want to make one small request, Your Lordship, sir. I'm appearing for the bank. The committee consisted of 5 persons, a RBI nominee, a Government of India nominee.
If your lordship just sees,
Besides the bank official, there's a RBI nominee, a Government of India nominee, and a shareholder nominee. They were all independent persons who had nothing to do with the banks playing any fraud in this case.
No.
And it kindly, therefore,
We have no doubt about their independence, Mr. Attorney. This all depends upon what the facts are.
Your
before them.
Lordship's question is certainly well placed, but the question is,
It is something like whatever in a writ petition or in counter affidavit is brought before us, based upon that set of facts, we take a view. Our view, despite the fact that nobody will question our bona fide, nobody will question our independence, but still our view can be erroneous.
certainly, we go by that.
Facts are not brought on
We
report.
certainly go by that proposition, but the High Court said, I've looked into all these aspects.
Yes.
High Court goes into an independent of the settlement committee. High Court says at 12:30, I
These are
don't
detailed-
find these are roving inquiries
Yes.
for no good reason.
Absolutely a non-serious,
inquiry.
my lord, non-serious, vague, bald, sweeping allegation on, my lord, a bank, on a my lord, we are not defending every transaction. We ourselves come. But, my lord, to say that therefore every transaction has to be, my lord, 5 million transactions happen every day. If you are going to put, my lord, a spokes to, my lord, through a process to say that this should, my lord,
Mr. Venkataraman, unfortunately, we are not saying that every transaction, but many of the transactions.
Certainly,
that
my lord,
take
but
place,
we- but
and
we are-
particularly
Provided.
under this, the direct or indirect umbrella of this IBC.
yes, yes, my lord,
These have become a very, very doubtful, very doubtful manner. A poor lady, a widow woman came to this court. She was before us with tears in her eyes. She wanted to pay 30 lakhs to a bank. They refused because they wanted to 46 lakh. She lost her husband. That's why the default was committed. We had to come to her rescue only to protect her residential house. When question of their case, they said, no. The value of the house is more than 50 lakhs. We have to recover only 46 lakhs. Why we should enter into OTS?
Those,
This
those-
is the stand these commercial wisdom people take before us.
There are-
And when the question of a 7-star hotel come, the stand is altogether different. Why our conscience will not click? Why should we accept it?
may I only persuade on one aspect?
Please produce the records. I would like to satisfy myself.
Your Lordship will do that. I only want.
My, so will be my brother. Let the original records of
The settlement.
the bank, complete details of the loan amount which was due as on 24th January 2025, the report of an independent valuer, if any, assessing the
Four valued groups will be produced.
market value of the hotel as on 31st December 2024, that is immediate before OTS, and other relevant records be produced.
Well, there are 4 valuation reports converging on value, except for the one odd value report, which said, well, this is a hotel. We can't sell a hotel. Well, valuation demands, hotel cannot be sold as some industry. One odd valuer gives a report of a 2,000 crores, which my friend is relying upon, who says it's a commercial property. It's one whole building is left out from the loan. Loan is not, ultimately the mortgage is only limited to a few sections of the whole. He values the whole. He values the whole as commercial, contrary to 4 bank authentic valuers who all confirm what this value of this hotel would be at a given point of time. 4 concurrent valuation reports. Well, the High Court spent a lot of time. Well, we'll certainly persuade your lordship. No difficulty.
Venkataraman,
But only thing, my lord,
we have recently, incidentally before my bench only, we have dealt with the auctioning of 2 hotels in Kerala. We have seen the people come forward to buy hotels also. There is absolutely, it's not that people there, the prospective buyers are not available.
we have no difficulty in producing.
Understandable. Suppose you say that I have tried my best in December 2024. I could not auction it. I did not get a single bid. and therefore I had no choice but to go for OTS. We will accept it.
That's precisely
That
what
is
happened.
commercial wisdom.
Precisely what
What
has
has
happened.
happened?
Not even otherwise.
We will produce the records.
Means that lot of.
We'll produce the
Just see one page, my lord,
Which I
page
suffered in
page
COVID,
252.
why should my hotel be sold? Apart from that,
We are not saying.
it's not that, I was not a default.
If a borrower,
Siphoning money.
Mr. Rotgi, if a borrower, small or big,
Yeah.
if he can save his mortgage property by paying to the bank a reasonable amount, no difficulty.
Correct.
But not in this manner. If at all, it seems to be. Therefore,
I think, Lord, your lordship will be satisfied on the manner. Lord, I'm sorry, but your lordship will
But
be
this is
satisfied.
not
I think,
very hanky-panky
Lord, this,
Yes, yes,
is-
my lord.
Lord, this is an
I
litigant
would
who
never
is
stand for
just
it, my lord. Your
going
lordship
hammer
can
and
trust us.
tongs. We'll
We'll show
satisfy
anything.
your
There's no
lordship.
difficulty. We'll show it, my lord.
Just
Absolutely no
see
problem.
one page.
Lord, the
page
other issue will be,
252
can you really upset
of the
TSs
paper
which are done in this manner?
Page
when complete contrast cases come before us, we get disturbed only because we do not know what's happening.
Absolutely.
Absolutely. There we are with your lordships.
But your lordship will be satisfied.
We'll
on
have to
the
pick the oranges from the apples, certainly.
No OTSs are happening in this country. If not every
Yes,
matter is.
Lord, a very, Lord, a
Unless
very,
there is any
we say this with a sense of responsibility, an extremely genuine OTS transaction is what has been brought unnecessarily into scanner. That statement we will make it to
Say
the.
notice to respond number 4 and 5, 4 to 6 only at this stage. Number 1, notice to respond number 1, 4 to 6, and 4 to 6 at this stage. Then also report is be produced. It's up to-
Therefore,
I am obliged.
Oblige your lordships.
Ah, chal raha hai.
But office report shows on 4 earlier occasions SLP is dismissed.
May I just place my matter, I'll place all of that, I'll place that, I'm for the petitioner. This is a writ. The only question, I'm pressing in this writ is my prayer A. What is happening? I'm not seeking any relief in respect of the matter, which is prayer B. The only relief is prayer A. Your lordships will have at page 17. What is happening in the state of Telangana, my lords, is
Mr.
that.
Prasad, how many time your petition will be entertained?
Plus, no writ petition. Plus, what has happened is page 237, your lordships, I had come up in a SLP all the way, and at page 237 is that order where the liberty was given. My lords, may just hear me for 1 minute. I see that, my lords, I have come in a SLP. Let me explain that, and the liberty was given at page 237. Your lordships will have that order.
File SLP. Please see the order.
Yes. My lords, page 237 is the SLP. And my lords,
Remedy. And you file another SLP challenging
no,
this.
no, my lords, I have filed only one SLP that was knocked out on the point of delay. The question was never considered. That came before Justice Narasimha's bench. The bench observed that earlier order. Yes.
Mr. Prasad, then
Yes,
that means if we dismiss the SLP, we decline to entertain SLP.
Yes.
According to you, the second SLP is maintainable.
No, this is a writ petition. This is a writ. My lords, the court indicated that please, we are not going to, because against the same, my lords, against the same order, the question, only the legal question, because in the state of Telangana, the court indicated that if you have to move, please move a writ. That's why that gave me a liberty. I am not seeking any relief in respect of this matter, but what's happening in Telangana, your lordships will just consider one thing, my lords. What's happening is reserve candidates are being counted if they are meritorious against general seats. So, my lords, which is incorrect, because the law is very well settled. If I on my own merit make it in the general, then it has to be treated as I am.
SLP, please.
The SLP was dismissed on the ground of delay. So the High Court also didn't engage with this issue. The court at page 237, that's the order I had myself appeared, indicated we can't engage in this because I have dismissed an earlier order, earlier SLP against the same matter by some other party. Therefore, if you have to file a writ. That is why the liberty was given at page 237. And pursuant to that, I am filing. I am not seeking any relief or stoppage of the process here. I am only saying my lords will settle the law so that for future there is no problem in Telangana. That's the only prayer. This your lordships may not interfere. My lords may record my submission straight away. I am not seeking interference with this process now. Because otherwise every year this will be happening, my lords.
Thank you very much. We will not entertain this.
All right, my lords.
The petitioner has already lost the first round of litigation up to this court with dismissal of SLP civil number 16170/2025. So we are just of the view that the second round through this petition is wholly misconceived, misdirected, and not maintainable. Dismissed.
Great.
Because I'm for the petitioner, my lord. These are two matters, my lord. My lord, similar matters have been, my lord, decided, my lord.
But these are fresh matters.
My lord, these are fresh matters. my lord.
Fresh. Any matter already pending where we can tag
My lords, as per the office report, no, my lords.
issue notice, trustee, liberty to serve the state through standing conflict.
Most grateful, your lords.
In the earlier notice recombination. Item 6. Already dismissed.
Is your lordship. Lordship, this particular matter, as per the office report, this is already.
Similar matters have already been dismissed.
Yes, your lordship.
Same order. Item 7.
Wait, please, Lord. But I've just set out these, just see the pleadings. Look, just see the pleadings against defendant number 17. I've just put them. Just hand that up. I've handed it. My lords may just see this. Look, I've just summarized I've set out the pleadings against 17. Just see that for a moment.
Apply order 1, rule 10, discretionary relief. Why?
Order 1, rule 10 2, but just see the pleadings here. Just see that for a moment.
This is not, it's a case which.
That a case cannot be maintained against a shareholder when the cause of action is against the company. That is your argument.
No, but there's nothing against the shareholder. Just see the pleading.
what I'm saying.
Ultimately, even against the shareholder, there should be some pleading. Just see that pleading for a moment. Give me, just indulge me. I'm not asking your lordship to open the papers. I've set it out here. Just let me read that, lords. I've set out in extenso. I've reproduced it exactly. Just see, my lords. The solitary pleadings in the plaint with regard to D17, plaint is from 38 to 107. It's a 90-page plaint. Para 18, the 15th to 19th and 21 to 28 defendants are shareholders of first defendant and are therefore beneficiaries of the trades done by first defendant on the plaintiff's exchange. Para 91, the plaintiffs state that in view of the fraud and default committed by the defendants are jointly and severally liable to pay the outstanding amount with interest in respect of the said outstanding trades to the plaintiff. Para 111, the plaintiff therefore submits that this is an eminently fit case to secure the claim of plaintiff by attachment of all the assets of so-and-so defendants, since the liability of first defendant admitted by them runs into hundreds of crores of rupees, and the defendants are consistent with an intention to defeat and defraud the claim, which is manifestly evident by the act of restricting inspection of exchange designated warehouses. Para Prere is this honorable court be pleased to pass a decree and order directing first, third to 41st and 45th to 50th defendant to jointly and severally pay 937 crores. Now they relied before the High Court on this para 87. Just see overleaf. Para 87, the High Court just merely sets out the para. Just see para 87. It is pertinent to mention that from September 2009, when the first defendant commenced trading on plaintiff exchange, till August 2013, the management and the affairs of first defendant was run by the 6th and 7th defendant. In fact, 6th and 7th defendants were actively involved in the transactions entered into by first defendant on plaintiff exchange. The entire conspiracy to defraud the plaintiff exchange was conceived of and orchestrated by 6th and 7th defendants. It appears that the companies owned by 6th and or 7th defendants and other companies firm, which in turn were owned by individuals who are related or connected to 6th and 7th defendants, benefited from or participated in the fraud. The directors, shareholders of first to fourth defendants are either family members of 6th and 7th defendants and or people accustomed to acting on instruction. I'm not a director. My father
was a director.
he resigned in 2013. Suit is filed in 2021. 8 years after he resigned as a director. No averment against my father.
The Roman 9, clause 9, Roman 9 of paragraph 87, that the shareholders are in collusion with the directors in respect of the fraud.
I'm not a shareholder.
You are a shareholder.
I'm sorry.
Paragraph 18.
It's a public limited company.
I'm a shareholder of the company. Your plea for dismissal is no dividends have been declared, so there is no.
I'm sorry, my lords. Please just see the law laid down by your lordships. This is a this opens
law
up.
laid down by us is not to substitute a discretionary order.
No, this is not a discretionary order with respect.
Absolute discretion.
Not 711 lies even with regard to if the entire plane can be rejected against one
Don't
defendant.
make advance arguments on 711.
Your lordship.
Your prayer is under Order 1, Rule 10.
And under 711.
711A. If you argue
No
on
cause of action.
711, you are out of court.
Lords, your lordships
Cause
are
of
well
action is made out. Simple.
I'm not just see. I've set out the judgments also in this note. I'll tell you what. In Church of Christ, your lordships have categorically held that even with regard to an individual defendant, if the entire plaintiff can be rejected, 711 lies. Now there is no cause of action shown against me. Just making a bold statement.
Can entire plaint be rejected?
I'm sorry, Mlad.
Can entire plaint be rejected when there is an allegation of fraud against?
Entire plaint has to be rejected. There's no allegation of fraud against me.
Doesn't matter.
Just
for that. What the remedy?
No, there has to
Order
be
1
some
Rule
basis.
10, Order 1 Rule 10(2) will make your defendant a party, a misjoinder. So for that, it's the discretion of the judge to keep him as a proper party. Simple.
Look, I'm saying
party is a
your
proper-
lordships have said that just by some artful pleading, look at the nature of the pleadings here. With this nature of pleading, every shareholder of every company will.
Please come to page 26, opening line of ground C.
Page 26, Milord?
Page 26, opening line of ground number C.
I'm sorry, just give me a moment, Milord. Grounds is the High Court failed to appreciate that in these circumstances, the petitioner only being a shareholder of, yes, I'm a shareholder of defendant number one. The description is only that I'm a shareholder, nothing else. Which means lacks of, in every claim against a company, lacks of shareholders can be roped in as defendants.
We agree with you. He is not a necessary party, but he can always be treated as a proper party.
But there should some averment against a party. I can understand if there was an averment that apart from being a shareholder, I have in some manner done some act, any act, even one act. There's nothing here, not a whisper.
No, sir. Where is your most respected father in these days?
I'm sorry, Millet.
Where
Really?
is your most respected father in these days? The whole country is eagerly waiting for red carpeting for him.
Look, only one thing, look, then let it be clarified that I can only be a proper party. Now, here, please see, if there's no absolute absence of any averment, not a single averment against a party, Millet.
Not a case where we will.
Please, Your Lordship.
Appeal for the petitioner, my lord. Lord,
Yes, I to meet.
yes. My lord, without hearing me on the first day, my lord, and then I've got everything. Environmental clearance, consent to operate.
And approach the High Court.
No, I tell your lordship, my lord. They've passed this order, and now the next date is April. Running, my lord. I know the stone crusher, the moment you hear it, everybody nowadays has a prejudice. But then, my lord, for 3 months, I'm a small entity. I opened in December.
So you can request the.
They've just, I had lots to say without hearing me. At least issue notice to me, my lord.
Therefore, if you have not been heard, please go and apply to the High Court. We will make some observations. You can approach the High Court.
My lord, may I just, a normal course, I should be.
Approved by an interlocutory injunction order passed against it by a division bench of the Uttarakhand High Court. Interlocutory order dated 7th January 2026 passed by a division bench of the Uttarakhand High Court. One of the grievances is that the order has been passed without even hearing the petitioner. So since the High Court is now opening after the winter break on 9th February 2026, first we say like this, it seems to us that the appropriate recourse for the petitioner would be to approach the High Court to appropriate applications for its impleadment as a party respondent, semicolon, to seek vacation / modification of the interim order, and to bring on record the set of facts which the petitioner wishes to, set of facts on the basis which the petitioner claims that the song SAUNG, Song River, is a non-perennial river.
Can I just, sorry.
Since the High Court is opening after winter break on 9th February 2026, we request the High Court to entertain these applications and pass appropriate orders by preponing the next date of hearing. With the liberty of aforementioned, the special petition disposed of.
Can I just say one thing? I don't want to interrupt a lot. My submission is that the relevant stretch of the Song River is non-perennial. That is the permission. Lordship, that Song Rivers, that is not my contention. I have produced documents. The document which they gave, is the reach of the Song River near Sankatiawala, Kala is non-perennial. That is my contention. Lordship will say relevant stretch of the Song River. That is my contention. My contention, even when I file a reply, is not, nobody can say the Song River is perennial or non-perennial. The relevant stretch, it's a huge river. this stretch, which is what the permission is given, the joint inspection report is on record in which,
No, no, your contention that you are away from the prohibited area of banks.
sorry, my lord, sorry.
He's saying that the place where he's.
So, Lordship is relevant stretch of the Song River, that's.
Claims and to non-preemptive that the site where the petitioner's stone crusher, you have stone crusher,
Stone crushed.
stone crusher is operational. The Song River at that near to that site is non-perennial.
Yes. I won't say anything further. I won't read. Lordship may read annexure P10, how this order came to be passed. I
How
won't
can
say
it be
anything.
perennial
P10.
and at one point the river
may
will
say-
be either perennial or non-perennial?
Lordship may see annexure P10. I won't say anything. Lordship may just read it. It was supposed to be listed along with a writ petition against my rival the next day. From this matter suddenly gets detagged and get listed. I won't say anything further. P10, Lordship may kindly see. I won't say anything further.
Anyway, we have requested the High Court to prepone the date and hear you.
No,
You apply immediately and get
No, the
an audience.
consequences are grave. On one day without hearing a crusher stopped, the small entity, the whole.
Mr. Vasan, these are environment issues, precautionary principle guides the area.
With natural justice, my lord,
Right?
without
So
natural.
a precautionary principle, when there is an RTI report, the website of the irrigation department shows it as a perennial stretch.
Which is why hearing us, under given a perspective. Anyway, Lordship has given me that
completely,
liberty. I won't,
Lost sight of facts.
I'll leave it. But. Oblige.
Lordship, there are two matters before your Lordship, 9 and 9.1. In a similar matter, Lordship, at page 212, annexure P6,
2013 का date में
You
same order.
double six stroke 20.
My lords, we represent Ghaziabad Development Authority.
They are here.
I will respond in 4 and respond 3. The matter is coming out on 23rd of February.
Responder 4 only or responder?
4 in 9, we are 4, and in 9.1, we are 3. Respond.
Accept notice on behalf of the sponsor respondent. Counter affidavit can be filed before 23rd February 26.
Please,
That they will decide all.
please,
Oblige.
oblige.
Then, no. There is a letter. Item 10, there is a letter circulated.
Please. This is the third time, my lord, the petitioner has been deboarded forcibly and illegally by the MP police and the RPF with with the RPF police. This is the third time this incident happened, my lord. He was not permitted to travel beyond his origination.
So what can we do?
My lord, this is a
How
clear
we,
violation of.
how do we examine these facts that you were dropped on the way?
My lord, I have filed the documents, my lord, that police himself given that letter saying that we are deboarding you due to prevailing.
You don't have a place of protest in your state.
My lord, this is the case, my lord, where the.
No, you have a right.
Assured, my lord.
You see, we are not curtailing your right. You have a right to protest.
Yes, ma'am.
Peaceful protest.
My venue is not MP. It is the venue of Delhi.
Yes.
My venue is not MP.
So-
In the midway, we were.
Mr.
we were
Consul,
deboarded.
Mr. Consul, have you applied to Delhi government authorities?
Yes, my lord, that letter I have annexed.
Yes.
There's no reply. Kindly see the letter which I annexed, 4th of October, I applied for letter. I gave a letter.
Letter
The number
you gave, have you
510.
obtained permission?
Well, permission, no reply has come.
If no reply have come, that does not mean the permission has been granted.
Well, even Lordship presume that even no reply has come after the representation is given, that means they have no grievance for conducting dharna at
If
Delhi.
you are ready to listen to us, then you please appreciate.
Yes, ma'am.
There is an earmarked dedicated place for conducting peaceful protests.
Yes, ma'am.
There you can have a political rally, you can have a non-political rally, you can have the farmers whom you are saying that you represent. The farmers can come there, they can protest for their demands, whatever. That's a part of the democratic process, no difficulty.
Yes, ma'am.
And for that, there is an earmarked place.
Yes, ma'am.
So first go to that competent authority, apply and obtain the permission.
When I gave a letter, my lord, letter, there is no reply.
The,
When I,
this is
after
the way,
when I even lordship say that I have to apply before the competent authority, I gave a letter.
Yeah.
Even if the letter has to be given in person, I have to come to Delhi at least.
yes.
But even half of the way, I was deported.
How have you, has he engaged you?
Pardon, my lord?
How has he engaged you?
My lord, he is from same place.
So for the purpose of wakalatnama, for
No, my
purpose
lord,
of,
this is not the way, my lord. Kindly see this. There is a violation, a gross violation of 19(1)D and 19(1)A.
like to answer any question that we are asking you.
My lord, I'm saying, my lord,
How did he come to sign your wakalatnama and papers?
my lord, as a council, I have to sign it, my lord, that I filed a writ petition on his behalf.
You are filing without any wakalatnama.
No, Vakalatnama I filed, my
Is
lord.
there?
Yes, my lord.
So he came to sign your wakalatnama?
No, he sent it by post, my lord.
Oh, like, he sent it from there. Now he has authorized you. Why can't you apply?
My lord, it is duly notarized by the local notary public.
Very good. So he has sent it. Now you are his authorized representative. Not
I send it, then there is no reply. That's why my submission.
Go and apply, please. Ask your clerk, you can apply online nowadays. You don't know to, even you are not required to go.
My lord, I'm not saying, my lord, because the question is that the appreciation has been given. No reply has come.
Well, thank you.
Thereafter,
Thank you. No case to interfere with you.
my lord, at least, my lord, kindly see, my lord, the last writ
No case to entertain this writ petition is vague. So ये लिखो, the writ petition is completely vague, evasive, and full of misdirected governments. The same cannot be entertained, dismissed. हाँ, ये रोज फाइल writ petition are dismissed.
Earlier, my lord, I was given permission to go to the High Court, my lord. I applied for the High Court, I filed a writ petition. There also they said we have no jurisdiction to entertain because you were deported MP.
No, but your standard does not permit to go to High Court. You are not, your standard is not less than Supreme Court. So you are rightly come
I
to
went to High Court. High Court order also I annexed, my lord. After that,
Very good.
after dismissal of the writ petition, I went to the High Court.
All right,
I
thank you.
pleaded before the High Court.
Thank
High
you
Court
very
said
much.
we have
Thank
no
you.
jurisdiction to stop anybody from MP other than beyond jurisdiction of Madras.
Thank
That is the
you.
reason I have come before Lord.
All right, thank you very much. Next. Item 12.
Lordship, I apologize in this matter. I'm sorry I couldn't circulate letter on time. Mr. Sibbal, who's leading me, he's unwell. So he asked me to make a request. I got information very late. I tried to circulate, but I had surpassed the time. So I'm just requesting 1 week adjournment, Lordship. He's not well. I spoke to him. So.
Your monopoly right is expiring when?
Sorry, my lord.
May 2026.
Lordship, the patent will expire in May 2026. But there was an injunction till the time the division bench passed the order. So I'm just requesting for a week adjournment. There was an injunction throughout.
Next week. Next week.
Much obliged.
But if your lordship, so far as the lady is concerned, there is no allegation whatsoever. But please come to P4 at 61. That's the FIR. And if your lordships are kind enough just to see para 7 at page number 67. Apart from the invocation of 420, 406, etc. together, Lord, just come to para 7. Complainant, may I place it? May I place it?
Para 17 of?
Para 7 of the FIR, Lord, it said FIR will begin at page number 61. I would like your lordship to see para 7.
Yes.
The complainant ultimately advanced large sums totaling multiple millions of dollars, but as market conditions surged, accused persons began dealing, eventually ceasing delivery. So the whole issue is not, it's really a commercial transaction that we could not deliver because of change of market conditions. Others are surplusage and nothing against the lady, Lord. Nothing whatsoever against the second respondent in the entire FIR. Nothing incriminating. She's just been roped in because of relationship, Lord.
What is the stage of the investigation?
Lord, I must tell you, Lordship, I stated, Lord, charge sheet has been filed.
Let it be investigated.
No, Lord, may I just say this? My Lord, charge sheet has been filed in the interim while the matter was pending in the High Court. Charge sheet has been filed, but I have not been served a copy of it, Lord. Charge sheet has been filed. It really makes out a civil transaction. I have not been served a copy yet because right now summons have not, process has not been issued. It's a case of not give or take of. Charge sheet was filed, my lord, but we don't have a copy. I can place that on record if your lordship permits.
Appear before the.
Charge sheet has been filed, then go and,
I'm sorry, my lord.
if charge sheet has been filed, then go and seek your discharge as per law.
Not, I leave it to your lordship, but not purely a commercial matter where they say it's only a question of delay.
Commercial law depends upon that initially what were intentions. If your intentions were right from the very beginning to dupe the investors, then you can't claim it a pure commercial transaction.
There was an MOU, and I must say this, for the second petitioner, there is, not this lady, there is nothing. May I just have a look at that for a moment?
Not a case that we can question.
Lord, may I just make a request? Lord, may I make a request then? Not the concern, I leave your lordship with one more concern. Lord, I was protected till a certain point of time. Kindly just see.
We know that is only there.
That will be lengthier. You will be released on bail.
Get full. And we'll take our remedies now.
Absolutely.
Yeah.
The petitioners are aggrieved by the judgment dated 22nd December 2025, passed by the High Court at Calcutta in bracket Port Blair bench, by their revision petition seeking question of FIR number 34/2025, dated 13 July 2025, registered at Cyber Crime Police Station, South Andaman, has been dismissed. We have heard Sri Siddharth Mitra and our senior counsel representing the petition and record and preview the report. It is clearly admitted that that after investigation, charge sheet has been filed. That means so, we are not inclined to entertain this petition. The petitioners, if so advised, may move an application for the discharge. Such an application shall be considered by the trial magistrate in accordance with the law. Next paragraph. With a view to enable the petitioners to join the court proceedings, it is directed that the arrest of the petitioner shall remain stayed.
Petition number 2. First petitioner company.
It is directed that the arrest of petitioner's number.
Petitioner is a company, Mr.
Sorry, not.
Petitioner is a company.
Not number 2. Second
Number
petition number.
Two.
Number 2, Latifa Banu.
Petitioners
Number 2, sir.
And there are 3 matters, not the other individual petitioners. In matter
petitioners in
2,
SLP criminal number 1790 of 2026 and SLP criminal number 12.
we'll give the name.
825 2026 also shall remain stayed, subject to their surrendering before the trial court within 1 week and furnishing adequate bail bond to the satisfaction of the trial court. Also, the learned magistrate shall be at liberty to impose such other conditions as may be deemed appropriate, as may be deemed appropriate.
But my lord, we make it 2 weeks is all I'm requesting instead of 1 week, because one of them is based here. Flights are sometimes a little problematic. 2
Right, 2 weeks.
And one request for discharge will not be influenced by the observations, because there are certain observations on merits.
Nothing, Mr.
My lord, there are some observations on merit, mensary, etc.
Thank you very much. Thank you.
Grateful.
Please, ma'am. My lord,
Description of sentence.
Yes, Mr.
please. My lord, the first round, my lord, the constables came and the ground was that they were simply following the directions of their superiors. Now, my lord, here, they are the advocates and the advocate was throughout present during the commission of the offense. The High Court records that CCTV is not clear and therefore his presence is disputed, whereas, my lord, there was a test identification parade in presence of an executive magistrate and thereafter followed by, my lord, his identification in the court. And my lord, two, my lord, the High Court records the phone which was found and which was used by this person, my lord. That phone was lost by somebody 6 months back. That's also wrong because it is recovered from him at the time of arrest. Please have a look, my lord, at page. And please see, my lord, he was described as an unidentified person, and it was told in the first complaint that once I see him, I can identify. Therefore, a test identification parade was conducted, my lord. Now, please have a look at para 14, my lord. Page 15.
Test identification parade, because the FIR was delayed, was after 4 months of the incident.
My lord, there was an inquiry prior to that. There was an inquiry, my lord. And please see, my lord.
Lawyer's presence was not spelled out in the FIR.
No, my lord, please see. I'll just.
When he goes to the Home Minister and then the FIR gets registered in April.
It
with
was.
regard, we understand that.
Please,
there
please.
were some influence, etc. But still then the fact of delay.
Please.
We have to examine the identification in light of the fact of delay between the parties. And admittedly, this person was advising some of your partner.
No, my lord, he was never, my lord. The High Court records that his father was once upon a time an
Your
advocate.
father was the lawyer of your partner who is the co-accused.
But my lord, he never appeared for me. Please see, therefore I'm pointing out, please see para page 15, my lord.
Yes.
Para 14, my lords, may have a look.
Necessary, the point is that in a case where the.
My lord, in the first round, my lord, when I pointed out that this may not be treated as a precedent, my lords have clarified in the order that in the peculiar facts and circumstances of the case, where there were constables simply, my lord, following the directions of their superiors, my lord. Here, my lord, please see the police officers and IPS officers, my lord. The police officers are a former MLA is before my lords, my lord.
The question is, it's a pendency of appeal. But the appeal will be heard, all these.
4 months, 364A, life imprisonment. The evidence is on record. The findings are flawed.
High Court has made a fine distinction between the conspirators.
Therefore,
the superintendent of police has not been granted suspension. Your partner has not been granted suspension. It's the lawyer, the constable, and the former MLA who have been granted suspension.
But there should be
there's
the
a
findings
clarity
can't
in
be,
the
my lord, contrary while granting
culpability.
suspension, my lord, with all due respect. The findings can't be contrary to the record, my lord. Please see, therefore I am pointing out, kindly have 2 pages, my lord. Para 14 at page, my lord, 15. Kindly have a look, my lord.
Yes.
It says, my lord, the applicant was throughout remain present when the act of ransom and kidnapping being made by the police officials. Hence, facts remains that the CCTV footage relied upon the prosecution seems to be not as much as clear. My lord, I was there, I identified. And 2, my lord, now please see the second finding.
Mr. can clarify that this observation has nothing, will have no bearing on merits. But the point is that once bail has been granted, why?
Lord, yes, I can understand, but this is an offense, my lord. Please appreciate a police officer is posted, my lord, 400 kilometers away. He comes to Gandhinagar from Amreli, and then he abducts. Then there is a transfer of Bitcoin where this MLA is involved. The advocate is present throughout the incident, my lord. Even prior to that, in the conspiracy, my lord, in the conspiracy right from 7th of February till 11th of February, they were in constant touch. The person who was released, that is Kirit Paladia, and my lord, this MLA and these lawyers were in constant touch, my lord, on phone. Those are CDRs on record. There were meetings in the circuit house, the government circuit house, my lord. That is all, that register is on record.
Question of connecting this entire evidence to establish that there was a meeting of mind or that there was
there is no
preconceived conspiracy. All these are matter of trial. Because
therefore, my lord, there was
substantial evidence.
But my lord, if the findings, my lord, are prima facie in contradiction to the evidence on record, just kindly have a look, my lord, what the learned judge records, my lord. Only one thing. Here, my lord, the High Court records that, kindly see page 16, my lord. What the High Court has recorded. that the mobile number 816, the last digit, claimed to have lost 6 months back. And then please see page 443, it says there is a finding that further the mobile number so-and-so recovered from the accused Ketan as per the deposition of so-and-so. So there was a recovery, the High Court records that it got lost 6 months back. My lord, the findings are prima facie, my lord, in contradiction to the evidence on record. I can understand suspension, but please see, my lord. So at least, my lord,
Assuming it's an erroneous order, even then we should not interfere. Unless we find a complete pervert order going completely beyond jurisdiction, where the High Court.
My lord, this is prima facie in my respectful submission, my lord. Once the High Court records a finding which is contrary to the record, my lord, then what more perversity is required, my lord, with all due respect. And please see.
We have heard and seen the counsel for the petitioner.
And two unidentified person, my lord. The High Court records he has not named. I was not actually knowing him. He came in Elantra car, my lord. That Elantra car he borrowed, that witness evidence is there.
The impugned order that the impugned order pertains to suspension of sentence and grant of bail during pendency of criminal appeal. We are not inclined to appeal with the same. Especially
and this may not be treated as precedent, my lord. Now the police officers are in line. At least my lords may say that, my lord. They may not get the benefit of parity, my lord. If at all my lords are, my lord, not intervening, my lord, because of the rules, my lord.
It goes without saying that such a prayer, if any made by the who are accused who are police officials, or shall be dealt with by the High Court as per their own right.
Please.
High Court has already rejected.
14 and 15, my lord. 15 is. No, the other police officers have not come. Only one, and he has withdrawn. My lord, only one. Only one. That is Kirit Paladia. He is not a police officer.
Police.
No, my lord. Superintendent of police. His application is.
No, that has been turned down.
No, it is
the High Court made
the
a
police inspector, my lord. Not the superintendent of police.
The superior police officer, the constable's bail were granted.
Constables were
The
granted.
superior police officer's bail has been turned down by the High Court.
No, only the police inspector, my lord. One of them.
Inspector.
The SP.
SP is two.
Yes, my lord. Now SP is waiting for
the
house.
Inspector is down.
With the addition of this line, they will be taken care of.
Please, my lord. We are grateful.
Came out of 15. Came out.
Please, my lord. My lord, this is a case where petitioner is seeking his right of hearing on the bail application. My lord, what is happening that bail applications are being filed by the litigants, and that is keep on adjourning without taking on the roster because of the heavy roster or any other reason. We have the compilation of इधर से दे दीजिए एक बार ये दिन दे दो उधर My lord, we have the compilation of various cases where such type of practice is being done, my lord. Please, my lord, I have the list. I have prepared on my own. It is not the list of compilation of all such type of cases. But suppose the case is at serial number 3.
Sir, report. So there is a slightly unusual prayer made in this special petition. It seems that the petitioner has approached the High Court for grant of regular bail. The petitioner has approached the High Court for grant of regular bail in a case registered under section 115, 190, 191 in bracket 3, 324 in bracket 5, and 351 in bracket 3 of the BNS 2023. The petitioner was arrested in that case on 11th August 2025. His bail application, he approached the High Court for grant of bail and his application came up before the High Court for hearing on 8th December 2025. It was adjourned to 20th February 2026. That is for a period of more than 2 months. The petitioner then applied for preponement wide impugned order dated 22nd December 25. His prayer has been declined on the ground that the bail application of his co-accused has already been dismissed. Next paragraph. During the course of hearing and on a query by this court, Komal and senior counsel for the petitioner submits that there are numerous bail applications pending in the High Court of Punjab and Haryana at Chandigarh, where matters are adjourned where the dates are being given months after. And as such, the bail applications are not being decided for a long period. On a further query and on an illustrative basis, he has submitted a chart of some of the bail applications which are pending since October 2025 and are currently adjourned to since May 2025 and are currently adjourned to different dates in the month of March 2026. You are for the state.
Yes, Your Worship, I am appearing for state.
Okay. It's not your fault, maybe.
Yes, yes.
Your fault may be that because you might be taking date or you might not be producing the record. But this is not the way the High Court should deal with bail application. If you don't want to grant bail, you reject it. For 6 months, for 1 year, you don't decide the bail application.
My lord, I have given the suggested measures also, where the state is seeking time for filing status report and on any other, there are various reasons for which the bail applications are being pending. There can be mechanism, my lord, because 7 days time is always given in regular bail in High Court. Within that period, they should file the status report so that it cannot be adjourned. Because once adjourned, then it goes after 3 months.
We had introduced a system there that when you file the bail, we don't know now, you file the bail application, you will give an advance copy in the AG office, and when after a gap of 1 day, the bail will be listed and the IO will remain present in court.
Earlier it was being listed, but now
Of course, now with the hybrid system, the IO can appear even online. But the bail application could be decided the very third day.
Yes, yes, but now it is listed after 7 days. And even within 7 days, no reply, no status report, no.
And that's why when we ask for the disposal, only these bail application disposal is shown.
Please,
The regular matters are still pending there. All 1985, 86 RSAs of criminal appeals, everything is pending.
please, ma'am. It directly affects the liberty of the litigants.
Next paragraph. ये सारे सर्विसेज से जाते हैं ना ये क्या इन्होंने लाइफ में कोई प्रॉब्लम At page 22, you can't blame the judge on a request made by counsel of the by the petitioner.
What is happening in some of the case is not being taken up. Thereafter, the counsel check the list. Then what is that on the request of the counsel adjourn and status report is awaited. There are also some of the cases. I have given 7, 8 suggestions, my lord, how it can be mechanized or improved, madam.
The biggest problem is that there is no orientation, there is no training system, there is no sensitization program of, after all, they are high court judges, they must themselves realize it.
My lord, I have given the copy.
क्या लिखा है भाई? ROPs have also been produced in order to show that how the matters are being adjourned repeatedly, how the bail matters are being adjourned repeatedly. Next paragraph. All that we wish to observe at this stage is that we are extremely disappointed to see as how the prayers pertaining to the liberty of individuals are being dealt with. It may be true that the dockets are very heavy and there are other matters which do require prioritization. Amongst the miscellaneous matters, nothing can be more important than the decision of the fate of, nothing can be more important than deciding the fate of the prayer to grant or refuse bail. Next paragraph. We expect Honorable Chief Justice of the High Courts to take some remedial measures. इससे पहले paragraph डारू कर दो. Almost shocking. Don't say shocking, okay? It is equally disturbing to know that the Patna High Court bail applications are not listed even for preliminary hearing for months. And more than 14,000-15,000 matches are pending. One of us, मेरा लिख दो, vividly recollect various matters coming to this court only for seeking directions seeking direction only for listing of their bail applications before Patna High Court. We have no reason, next paragraph, we have no reason to doubt that Honorable the Chief Justice of the High Courts are cognizant of such prevailing conditions where the High Courts unfortunately are not even able to decide bail applications on time, within a reasonable time. This is happening despite the fact that on occasions, this court has indicated timeline for adjudication of such type of matters where there is an inbuilt urgency, keeping in view the very nature of a relief sought. It seems that those orders passed by this court have not been able to bring the desired sensitivity as a result of which, due to which, the High Courts have apparently not evolved any robust mechanism for time-bound adjudication of the bail matters. Next paragraph. We are conscious of the fact that listing and prioritization of the matters for the purpose of listing is the exclusive prerogative of the Chief Justice of the High Courts, they being master of their respective rosters. So, however, if people are languishing in jail, semicolon, their bail applications are not being even heard, and they are completely in and there is a complete uncertainty as to when will they be able to know the fate of their applications, comma, it seems that this court is under a bounden duty to lay down certain mandatory guidelines. However, before we do so, we direct the Registrar Generals of all the High Courts to send complete details of the anticipatory and regular bail applications pending in the respective High Courts, along with the date of filing, comma, date of decision, or the next date of hearing. All the bail applications Such details shall be furnished for the time being in respect of all the bail applications which came to be filed on or after 1st January 25. Rather than filed on or after 1st January 2025. So, bail applications filed prior to 1st January 2025 are also pending. यहाँ पे है ना anticipatory bail application, then stroke करना applications for suspension of sentence. Three category. However, if such applications filed prior to 1st January 2025 are also pending, comma, details thereof shall also be furnished. Next paragraph. Adverting to the case in hand, comma, we find that the bail application filed by the petitioner is coming for hearing on 20th February 2026. We request the Honorable Judge to decide the same on merits, either on the date fixed or prior thereto, if an application or prior thereto, provided that the petitioner seeks preponement of date. Next paragraph. Within 4 weeks, the matter for further consideration on so and so day. All the state governments are directed to fully cooperate high courts for early and time-bound adjudication of the bail applications, stop prayer for suspension of sentence. The High Court shall sentence of the states should be ready with the relevant information as and when the bail application is listed for hearing, provided that a copy thereof has been handed over to, has been submitted in the Office of Advocate General and or the public prosecutor at least 3 days in advance. At least 3 days in advance. In such like matters, the investigating officers or the authorized officer can be permitted to appear online also. Next paragraph. The Registrar Generals of the High Courts are further directed to circulate disorder amongst the honorable judges of their High Courts to our fervent appeal to them for expeditious disposal of the pending bail applications. Next paragraph. The Honorable Chief Justices are also requested to revisit their roster stroke listing arrangements, and wherever they find that there is a mismatch between the total pendency and the bench allocated for deciding such matters, comma, they may consider the desirability of listing the bail matters before they may expand the roster for listing of the bail matters. Post the matter on so and so date.
May I make one more submission, my lord? My lord, in cases of suspension of sentence, sometime what is happening that custody is more than 7, 8 or 10 years. Suspension of sentence bail application either pending or disposed of by listing the appeal. But appeals are also not being heard. And 7 years custody, 10 years custody after conviction of total, my lord may also call the record. The appeals in which custody is almost.
Right, Dr. Pankaj, that there are the system that has its own difficulties. If you start taking your only criminal appeal, the matrimonial cases, the other admission matters, academic matters, those get delayed. So some balancing has to be done.
There is no doubt that that is heavy roster, but 10 years custody is something.
No, undoubtedly, we don't, we strongly disapprove rather, if there is custody of more than 10 years, even normally in a case of life sentence, barring a few cases where death sentence is there or the crime is so heinous that life imprisonment means that he has to spend 40 years or so. In such cases, there is no question of granting bail. But then you pass an order, dismiss it, matter ends. Somebody would have, if they have a right to go in appeal, let them come. But keeping pending is what is bothering us. You pass an order, that is prerogative of the judge. Whatever order they want, they let them pass. Right, let us see what.
Items 36, 37 are those Bengal SRs. In the sequence, it was supposed to come after 16. So is that being taken up?
We'll take up to.
Because sequence was issued this morning. It said it's after item 16. Items 36 and 37.
After this,
Fresh matters.
1 or 2 fresh matters are left.
Yes.
After that,
These are fresh. 36, 37 are fresh matters. Bengal SIR.
those are will take with us.
I'm grateful.
Just a minute, only 2 matters are left.
Very well.
I'm grateful.
Yes, item 40.
Yes, my lord, I appear for the petition. One.
You can argue from there now.
Only difficulty is, my lords, the elections are slated to, my lords, on Friday. My lords, my objection was dismissed only on 22nd. Also on 23rd, immediately I have moved the High Court. Also immediately before the High Court, I have moved, my lords, the very next day.
They want to oust your opponent at the stage of nomination itself.
No,
You don't want to face in the election.
no, my lords, the only difficulty is that, my lords, I have moved the High Court immediately on the next day. My lords, no hearing has been given.
If you win the election, then he is out by itself.
That is it. May I only make one request, my lords?
23rd. Options open.
Yeah.
Not legal option.
Also, I'll withdraw this petition. Also, only request is that this objection I may be allowed to raise at an appropriate stage.
Entitled to.
Because the difficulty I'll face otherwise is that the order of the returning officer which is against me.
Counsel for the petitioner seeks and permit to withdraw this petition with the liberty to raise all the to raise all the contentions at an appropriate stage. Ordered accordingly.
Very. I am highly.
Item 41.
Lordship, almost more than 90% encroachment has been removed from the government and forest land, Lordship. This fact is already acknowledged by the respondent number 225, Lordship. May I read, Lordship, annexure P5, Lordship? Page number 36, Lordship.
But why not remaining 10%?
Actually, Lordship, but there is a one beam, Lordship.
My lords, I am appearing for R1, my lords, for Miss Chandel, my lords. My lords, my only two submissions, my lords. The first is, my lords, in the month of May,
If that pillar of the house,
my lords,
beam,
my lords,
normally they don't construct pillar in Himachal.
my lords,
But that beam or whatever support to the roof,
my lords,
that is coming in the government land.
my lords.
And if that is removed, the entire house will fall down.
My lords, they were new while they were constructing, my lords.
Like they knew.
Who is he, Lordship?
They were new
That
the
is-
consequences of my lords. Still they constructed, my lords.
Who is he, Lordship? In which capacity is he appearing?
My lords, again, in the month of January, my lords, the petitioner again encroached the government land, my lords.
That we will.
They are using as a warehouse. They have kept their the materials, my lords. They are,
Issue notice, returnable and so on. So that you appear for whom?
my lords, are R1, my lords. Miss Chandel, my lords, R1,
R1.
my lords,
Or you are the complainant.
my lords.
Petitioner.
Original petitioner, my lords.
Original.
Original petitioner.
Then say, so and so accept notice on behalf of issue number 1. Counter affidavit to can be filed within 4 weeks. Then say, meanwhile, the parties are directed to maintain status quo at the site. That means that neither the house of the petitioner shall be demolished, nor the petitioner shall be permitted to raise any fresh construction.
My lords.
So if the petitioners indulge in raising fresh constructions, comma, respond number 1 and the authority shall be at liberty to bring it to the notice of this court. And in that case, the petitioner will be liable to face the consequences.
My lords, meanwhile, they kindly directed to remove the,
The other response.
to clean the, my lords, the path, to clean the path, my lords. They have,
No path.
as per my instruction, my lord, they have kept their
There is no path.
materials to construct the buildings. my lord.
You take out the photographs, you will file counter affidavit and you place on the court the complete site plan, photograph and show that how the passage has been improved. Then we'll see what is to be done.
My- Obliged.
Deeply obliged, Lordship.
वो देखो उनका West Bengal वाला था.
Uh, 36 and 37 are fresh matters. 21 is after notice.
Judge, may I just, I've prepared a note. I'm appearing for the petitioner in 37 and also in 21.2. So I just have a note because we need some urgent orders here. So would your lordship please just take this up along with, I'll request the court master to hand in IA 26838 of 2026. You got a copy of the note?
21 is on the board, that's also, that's also ECI 21, which is the 21.
One, you are appearing in item 37.
I'm appearing in 37, but I'm pressing just now because this is a matter.
37 is by Madam Mamta Banerjee.
Yes, and
And there is another matter, 36 by Mr. Joy.
I'm in 36.
You are.
I'm in 36.
Yeah.
32 petitions.
Well, it's connected to 21 and I'm requesting the court master to hand over in 21.2 IA 26838 of 2026. So, because the cross references in my note are to those particular documents. So I'll just request that. And I'll place this quite rapidly along with the writ petition. And there's an earlier IA also 1884. Would your lordship have the note?
Note. All right. Yes.
Now, my lords, with your permission, may I just place, my lords, since
go
Justice
behind it.
Pancholi
Don't
was
push
not
me.
there on in the bench on 19 January 26, may I just place this court's order of 19 January 2026?
19 January, is it the same order when Mr. Sibal wanted us to issue some direction
Your
and we
lordship,
could
they've
go
already
direct?
passed direction, so this is just in, in furtherance of that. Your lordships have that.
What is that order of?
It's at page 30, 30 of the IA.
Page?
30.
Not confused. That's it.
IA 26838. Your Lordship has that?
Yes, yes.
Yes. Justice Patolia. I'll just go through this so that we'll get the thread.
The order starts from page 31.
That's right. Para 2. It appears that approximately 1.40 crore individuals have been issued notices for the purpose of document verification. These notices are broadly categorized into three parts, mapped. That is the category of voters who are linked with the 2002 SIR. Unmapped. That is the category of voters who are not linked with the 2002 SIR. And 3. The third category involves logical discrepancy, accounting for approximately 1.36 crore voters. The documents brought on record by the parties indicate that within the category of logical discrepancies include inter alia, a mismatch of the father's name, a mismatch of the parents' ages, a difference in the parents' ages of more than 50 years, a difference in the grandparents' ages of less than 40 years, and those having more than 6 progeny. With a view to enabling the person who are, as of now, included in the category of logical discrepancies, we deem it appropriate to issue the following directions. The names of the persons figuring in the logical discrepancies may be displayed at the Gram Panchayat Bhavans, public places in every taluk and block office and every taluk subdivision, as well as the ward offices in the cities and the urban areas. Persons likely to be affected are permitted to submit their documents, objections through their authorized representative. Such an authorized representative can even be a booth level agent. There shall be an authority letter in favor of such representative, whether signed or thumb marked. Documents and objections may be permitted to be submitted at the Panchayat Bhavans of block or block offices. The Election Commission of India shall issue instructions for providing an additional 10 days time for the date of displaying the list in a Panchayat Bhavans block office to all persons who have not yet submitted their claims, documents or objections to do so within the extended period. The state government shall provide adequate manpower to the Election Commission of India and the State Election Commission for deployment of Panchayat Bhavans block offices to handle documents, objections, and hear persons likely to be affected. In this regard, we direct each district collector to meticulously follow the instructions issued by the Election Commission, state government for deploying adequate staff and forces for ensuring smooth functioning. Director General of Police, West Bengal, Superintendent of Police in the district, and the collector are instructed to ensure that there is no law and order problem. All affected persons may, in addition to being given an opportunity to submit documents, materials or objections, also be heard at the time of either in person or through the authorized representative accompanying them for the purpose of making an appropriate decision. The official will receive the documents or record a hearing to the affected person, may also certify the receipt of documents, and that important direction in para 10, Madhyamik class 10 admit card, which discloses the date of birth of the candidate, may be submitted apart from the Madhyamik pass certificate during the...
Direction number 10 was issued.
Yes, yes.
Because we, at least personally, I had the advantage of my two brothers from West Bengal being with me.
Yes, yes. That was,
And they were able to point out that this is the way in certificates are issued in West Bengal.
That's right.
Therefore, because of their having been pointed out, so that's why we included in 10.
Now, Manoj, may I request you to take up the note so that we just very quickly and rapidly go through that. So please see, this is a brief note on behalf of the petitioner. Your Lordship has it. That's the heading, right on the cover page. Sorry. Of the note, which is a snapshot. Now, the number of days left for the final publication.
Separate note you are talking?
Yes, well, just to save time, this is the full the submission which we are going to make and the request. Number of days left for final publication of electoral roll is 11 days. So that's up till 14 February 2026. Number of days left to complete the hearings is now just 4 days left on 7th February 2026. Number of voters categorized on a draft roll as unmapped is 32 lakh. Number of voters categorized as logical discrepancy post-draft poll publication is 1.36 crores, which is 20% of the electorate of West Bengal. Number of hearings held since, now this is just to give you an idea, since 16th December 2025, which is 41 days, so far they've held 88 lakh hearings in respect of 88 lakh voters, which is at the rate of 1.8 lakh per day. The number of hearings pending is approximately 63 lakhs. And this will mean that if we are to, which an endeavor would have to be made, if we have just 4 days left, the speed of verification will have to go up to 15.5 lakhs per day, because there are just 4 days which are left for 63 lakh. Documents pending for verification at the DEO level in 11 days from 88 lakhs hearing completed. So we have indicated that number. Documents verified by DEOs in 41 days was 52 lakhs. Number of, now just note this because there's a set of submissions here. Number of micro observers deputed without any statutory basis. This is 8,300. I'll just come to, I'll make a short submission on this micro observers because they don't seem to be contemplated under the constitution at all. Even under their manual of operations, it's a very, very limited role which they have on election day, but not the activities which have been deployed right now, which has been given to them at this stage. Number of approved documents rejected after hearing stage commenced. Now, this is one of our grievances. The panchayat residence certificates, the family registers, the domicile certificates, Aadhaar card, OBC certificates, and land allotment certificates. None of these are by themselves being accepted. And despite orders of the court. And then, my lords, we have mentioned because people are waiting in 4 and 5 hour queues over there. Now, please go over to page 2, para 5. We've formulated the specific point here. Now, the first suggestion is non-statutory category of logical discrepancies used to issue notices to 1.36 crore otherwise eligible electors. Now, this is our request. Direct the ECI to upload the reasons of each elector flagged as logical discrepancy cases online on the ECI website. May I request you to directly go to page, we've explained this more fully, but just go to page appendix 1 at page 8 of the same note. Now, I'm just giving you an example.
Appendix 2.
My mistake. Please go to appendix 2, appendix 2. Page 11.
Page 11.
Yes. Now, pursuant to your lordship's directions, this is what is being put up. But as you will see, so the name of the elector is there, age, gender, and then the category notice just says DM, which is discrepancy in mapping. But the person doesn't really know when this is put up on those, the reasons are not indicated over here. So what is the reason for this particular discrepancy in mapping?
Mr. Diwan,
Yes.
we were informed that this is on the website, but when the notice is given to the person
Yes, you're right.
concerned, the particular
Yes,
reason
we've given you that
is
example.
put up.
You're right, Biloj, but there is a lag as far as those notices are concerned. So we are suggesting some short reason should be indicated on this as well, because it will help the process. People will know why are they on that particular list. What's the reason for the list?
Diwan,
Yes.
to the extent that person must know the reason.
Yes.
Is absolutely justified. There is no difficulty. The only question is that what is the mode of communicating that reason? What we have been told on the date, because on 19th when we were passing this order,
Yes.
we were also, because we thought that we are issuing very comprehensive direction so that there is every procedural part is smooth sailing.
Yes.
Now we were told on that day
Yeah.
that this list is not the only communication. Communication is individual notices to the person
Yes.
included in the list of discrepancies.
Yes.
And that notice then define that notice.
Sir, we've given you a sample in the note. You're right. You're absolutely right. For example, page 9 and 10.
All notices are containing the reasons. Lordships have also permitted them to take a representative lot of whether BLA or otherwise as they want.
Because this will certainly help if it is up there on the note and a short reason is indicated. The notice may carry, given the numbers which we are dealing with, by the time somebody receives it, reads it, etc. So this is my first suggestion.
So for example, page 9 as you are referring.
Yes, page 9, we've indicated over there.
Now, it said due to the mismatch between the name of your father as well
Yes.
as the current electoral rolls and
Yes.
as given in the electoral roll prepared during the previous SIR,
Yeah.
as per the linkage shown in your enumeration form, you
Yes.
seem to be incorrectly linked with the electoral rolls. I think
Yes.
this is a reason, a well-explained reason.
Yeah, so now I want to just take this, I'm obliged to your lordships. Now please go back to my note, just go to page 2. I'm going to now build on this point.
Page 2.
Yes, so on page 2 of the note, 5A1, I have made the point, then your lordships will see upload reasons is what we suggest. Now number 2, in 5A2, direct the ECI to withdraw all notices under the category which pertain only to name mismatch. Now look at this. Yeah.
Page 5, page 5. 5.
I have nothing to say.
5K.
Yes.
This A, then clause 2.
Yes.
Where you are
The name mismatch.
Are you referring to the cases? Say,
Yes.
for example,
Yes.
just on illustrative basis.
Yes.
So, for example, one person writes Datta.
Yes.
Somebody may may spell it as DUTTA.
Oh.
The other may spell
Yes,
it
absolutely.
DATTA.
Absolutely. Yes. Yes.
That is one part.
Yes.
Similarly,
and Bandopadhyay.
Banerjee
Yeah.
and Bandyopadhyay. And
Yeah.
similarly, in Sarma,
Yeah.
somebody may write SH,
Yeah.
somebody many of them write SARMA.
Yeah, so your lordships have exactly anticipated what we have set out in paragraph 7A. In fact, we've given Datta, Ganguly, Roy and Ray as examples. But we've given actual examples of what is being faced at page 8.
But
Now,
according to you, you see,
look at, sorry. One is
tell
name
them to
mismatch.
withdraw the notices will be, is something very impractical thing because notices have been issued.
No, I'm suggesting. My suggestion is that our estimate, it's an estimation, that in the logical discrepancy cases, please go to paragraph 7A on page 4. Just go to 7A of the note, page 4. A majority of the logical discrepancy cases, more than 50%, which is around 70 lakhs, are cases of minor name mismatches and spelling variations. And we've given the very examples which your lordship. Page 4 of the note. 7 subsection
Yes.
Para A.
A.
A majority of the logical discrepancy cases, more than 50%, are cases of minor name mismatches and or spelling variations, and your lordships knows. Now we've given you an actually of actual electors. Please go to page 8. This just builds on the point which your lordship made. Please go to appendix 1, which is page 8 of the note.
Page
8. Now, your lordship has it. So now Mr. Chirag Tibrewal, his discrepancy was father's name mismatch. My father's name was Kumar in the middle. Your lordship has it. Last column. My father's name has Kumar as the middle name in the 2025 SIR, which was not there in the 2002 SIR. I have been served a notice and called for a hearing on 27th January. Look at serial number 5.
Three, just see 3.
All right, 3. Well, please see, this is Ajimuddin Khan. Now see what has happened in his case. Father's name is shown as KHA, Alauddin Khan
The Bengali.
in the Bengali, whereas it should be Alauddin Khan Because, my lords, you see, from the one, from Bengali into English and vice versa, you can lose this. Yes. This may be software.
Illustration number 3 may be slightly difficult, because here you are saying Azimuddin. No, Azimuddin is.
No, it's Alauddin. Father's name, my lords, father's name.
So the spelling mistake is, or spelling difference is in the name Alauddin Khan.
No, that's his father's name. My lords. Please just see.
The Chandra Matra there.
Yeah.
The form in Bengali.
Okay. Khan has become very but not want to help you.
Yes.
But
And this is not in other states. Okay. This is
The 2002 electoral roll was in Bengali. So when they translated it for this purpose.
Out can be. I don't, all right. What is your solution? Because then we are also thinking.
no, so because these, so there are two ways of looking at it. One is, look, this name discrepancy, my lords, which is the bulk of it, is cramping even the available time, which is just a few days. So these name discrepancies, my lords, should not be within this logical discrepancy to knock out people from the electoral roll, because look at the inconvenience. Look at one of those notices.
Your solution, Mr. Dwivedi, have you think about it?
Actually, more than a crore thing have already taken place. Few more which are left.
No. What about this kind of discrepancies which are not even a spelling mistake, which are only on account of the how you speak in the local dialect? This happens pan India. It happens in Haryana also. It happens in Punjab also. It happens in West Bengal. It will happen in Tamil Nadu also.
Yes. So we don't have instructions.
Because-
Being chart given to us just now, my lord, it's not there in the IA, etc. But ordinarily, what my instruction.
Suppose, Mr. Diwan, let's find out.
Name mismatch.
Well,
It's not being
I
purged.
don't want to interrupt. I don't want to interrupt.
Please don't purge people.
Mr. Sibbal, you are unwell today. You better take rest.
I am going to, Milad, I don't want to interrupt your lordships will remember, Mr. Dwivedi made a solemn statement, then where is this kind of discrepancy, we're not going to bother about it. Your lordships will remember that. He said if it's a question of spelling this, I'm not going to, this is not something that will be.
Bengali, if you were in Bengal, Mr. Dwivedi, you will be pronounced as Dwivedi. B will become B.
And you will also be ousted.
Yes, then you will have been spurged.
Language doesn't have a war.
Gujarat will become.
Bengali language doesn't have a war.
Sir,
Or yeah.
instead of my brother being addressed as Vipul, they will address as Vipul.
On this aspect, may I just sorry.
But my name, there will be no mistake, because it's a basically Bengali name.
Sir, it may be, sir. Sorry, sir.
With your
Because you-
permission, could we just have an insight over here from? Yes, please.
5 minutes.
If you allow me.
So, go ahead.
So my understanding was that mere spelling mistakes notices are not being issued.
Are being sent.
But now that this chart is being issued, is shown to your lordship just now, my lord, I need to get an instruction. Your lordship may have it tomorrow or day after, whenever I can.
The executive head of the state is also very much present. If the state government provides a team of officials who are well conversant in Bangla and who are well conversant with the local dialect,
Yeah.
and they scrutinize these, just scan through this and tell the commission that this is here only a local dialect mistake
Yes.
and not any identity mistake.
Yes.
That will help them.
No, it will help them, but it's apparent.
Oh, Johnny.
Actually,
Apparent in some of the cases on illustrative basis it may be, but it will become humanly impossible for you or for us to go through and to.
Lordship
May I explain you, sir?
Give me time till tomorrow, day after, my lords, then I can get back.
May I explain you, sir?
Because in my view.
Because I belongs to that state. I am a
Can there be any doubt, Madam?
No, sir. No, sir. I am very grateful, sir, because of your kind
If it's
kindness, my humble regards to my Honorable Chief Justice, Mr. Bagchi and Mr. Panchali also, Panchali ji also. Thank you very much. And my humble regards to Mr. Dwivedi and others, my opponent lawyers also. Sir, the problem is, always our lawyers fight for the case and they're fighting from the beginning. We are also. But sir, when everything is finished, when we are not getting justice, when justice is crying behind the door, I quote Rabindranath Tagore, then we thought that we are not getting justice anywhere. So many times I have written 6 letters to Election Commission, including all the details, but no reply, sir. I'm a bonded labor, sir. Maybe I prefer that. I'm a very less important person. I prefer that. Sir, I'm from a common family, but I'm not fighting for my party.
Madam Mamta, sorry for interruption. The state of West Bengal, in its own right, has filed a petition, right? Today, of course, you are also coming in your individual capacity, but state of West Bengal, in its own right, there is nothing wrong in that. State of West Bengal has also filed a petition.
State of West Bengal is not.
One of the best counsels in the Supreme Court, fortunately, are there to not only are to represent the case of the state. Mr. Sibbal appeared on that day. Today also, incidentally, Mr. Diwan is there. Then in the other matter, Mr. Gopal is there. The best of the team, the legal team in the Supreme Court is there to assist us in the matter. Mr. Sibbal, though slightly elevated.
Sir, if you allow me 5 minutes only.
Now he is there.
Only 5 minutes only.
We will give you, not 5, we'll give you 15 minutes. We are only pointing out that on 19th January, when the matter came before us, Mr. Sibbal very eloquently he explained the procedural difficulties which the state was experiencing and where the state had some genuine apprehension for exclusion of the bona fide citizens of the India, citizens of West Bengal, the residents of West Bengal who are citizens of India. So therefore, those directions, the direction which Mr. Diwan just read out were issued. Today, in your petition, some additional issues are being flagged. Absolutely right. Issues are being flagged. Every problem has a solution. So we must look toward the solution in order to ensure that no innocent citizen is left out. This SIR is based upon only on 3 grounds. Dead persons excluded, no difficulty, neither you will want, nor anybody will plead for the dead persons. Similarly, the persons who are disqualified to remain for any reason, somebody is convicted, whatever may be any ground in the law, you will not plead their case. Similarly, those migrants, the word is migrants, migrants is also one of the ground. Those who have left West Bengal, even you will not plead there. But the genuine persons must remain there. Now, among the genuine persons, one of the ground, as Mr. Diwan has today flagged, and rather we are thankful to you also that in your petition now this issue has been raised, that because of the local dialect or because the manner which the Bangla people will proudly pronounce a name or it because of that, and this all because nowadays AI assisted computerization, that you are speaking Datta and they are recording something else. If this kind of things are happening, we will find out a solution. They will have to find out. They can't. They will not like to run away from that responsibility. That by virtue of this kind of mistake, the genuine and bona fide person must not be excluded.
Sir, what happens
just
now?
only one
Sir, what happens now?
permitted before they could open millets. Millets, insofar as the Election Commission of India is concerned, I represent. In that matter, so far we have not been served with any pleadings. We are clueless what their grievance is. If it's been there, if it's served on us, a week's time given, we'll get all instructions, we'll place it before your lordships and look forward to any genuine difficulty to be redressed.
Week's time will be too late.
So be it, millets, let it be on Monday.
Week's time, let them.
Let it be on Monday.
Sir,
Because millets were clueless what the grievance is.
sir, this is not.
I understand.
Item
This is-
21 is
Please
being-
allow me,
There
sir.
is
The reply in
It has not
21.
been served.
You are right in saying that you have not been even given copy because
No.
the matter is coming first time for hearing.
Indeed.
The only thing is that since all this entire procedure has a timeline. At that timeline, we had extended on 19 January for another 10 days.
True, my lords.
But that 10 days time is also now, because they rightly pointed out by Mr. Diwan, that out of that extended period, only 10 days are left. 4 days are left. After those 4 days, only 11 days are left. So this being a timeline, we can't grant you the luxury of 1 week notice or 2 days.
On Monday, so that
Sir.
we'll come to know what the grievance is and we'll
Sir.
suggest or place with your lordships the remedial
Sir,
measures.
please allow me to finish my
So in
point,
principle-
please.
In principle,
Yes.
if it is happening that Roy, Datto, Ganguly, Upadhyay, anyone like this, by virtue of the local dialect, if the name is being spelled out slightly different than what the accurate words might be, somebody can say.
Precisely.
In a given case, we do not know how Tagore is also defined. Maybe somebody put the E in the last, somebody may not be putting E. But that does not mean Tagore is not Tagore.
My lords,
So you also have to
Millets,
come out with a.
what they cannot
technical
afford
way
to
out.
forget
So
is-
is the state can suggest us a way out. We will.
my lords, even the field staff are local, they pretty well know all
Respected
these
Chief Justice, sir,
not that
I
something has
am
been imposed.
giving you the example. I can show you some photographs. If you allow me, only I want to submit, sir, I want to lay, because it is not my photograph. All the Bengali leading newspapers, it is reported. You'll be surprised to know the, sir, only, sir, my submission, sir.
No,
Sir, their SIR process is only for deletion, not for inclusion. Mismatch, not only the title, sir. Mismatch, mismap, unplanned. Now suppose a daughter after marriage, she go to the in-laws house. Now why she's change her title? Why she's using the husband's name, husband's title? That is also mismatch.
It can't be.
Yes, sir, they have done it, sir.
That's why we are.
Now,
That's
sir,
why we.
only I just want to say. Number two, sir, there are some daughters who married and shifted the in-laws house. Their name also just unilaterally deleted.